First segment that we're going to be showing is Garrett without a
Alright,
nurse.
boys and girls, open your pages to page 16. We'll begin to read from there. Garrett, would you like to start? Garrett, you okay? Garrett, Chris, go get the nurse. Garrett, are you okay?
This segment that we're going to show is Garrett with a
Alright,
nurse.
boys and girls, open to page 16 and we'll begin from there. Garrett, would you like to start? Garrett,
Dad, are you okay?
are you okay?
Garrett.
Alright. Well, I'm just
Just relax, Garrett.
Real quick.
Just relax.
Alright.
Garrett, would you like to read or would you like us to move on?
Can you read, bro?
The case at hand is Cedar Rapids Community School District versus Garrett F., 1999. Garrett F., a minor and student in Cedar Rapids Community School District, is wheelchair-bound and ventilator-dependent. He also needs tracheotomy suction, clean intermittent catheterization, and repositioning every hour. He requires assistance in attending to his physical needs during the school day. The school district declined to accept financial responsibility for Garrett's services in order for him to be able to attend school. The school district believed it was not legally obligated to provide one-on-one care. An administrative law judge concluded that the Individuals with Disabilities Education Act, IDEA, required the school district to provide school health services, which are provided by a qualified school nurse or other qualified person, but not medical services, which are limited to services provided by a physician. The school court and the Court of Appeals affirmed, despite arguments from the school district, that such one-on-one care is too costly and too involved to be considered anything but medical in nature. All justices are being played by one person, Chief Justice Ryan Rehnquist. The question at hand is, do schools that receive federal funding under the Individuals with Disabilities Education Act have to pay for one-on-one nursing assistance for certain of their disabled students? This is how the case played out.
Next up, case number 96-1793, Cedar Rapids Community School District versus Garrett F. Ms. Seeds, please address the court.
Thank you, Your Honor. It has already been proven through the Individuals with Disabilities Act that schools are not required to provide medical services for students. The issue at hand is whether or not receiving treatment from a nurse is the equivalent of getting the same treatment from a physician. It shouldn't matter who is performing the medical task. All that matters is that the task is medical.
Your argument, Mrs. Seeds, seems to be a little off base. Based upon what you're saying, I would say that the CIC could be a medical service, but then again, we have the Tatro case. So therefore, your argument through rationale seems flawed.
Well, Justice Rehnquist, catheterization, even CIC, is often thought of as medical service. The issue happens to be that if we're left to determine what actions are thought of as broad medical services and which are assumed to be school nursing services, yes, CIC is now recognized as related service that is provided by the school nurse. However, the issue at hand is whether Garrett's other needs are covered as well.
Pardon me, Ms. Seeds, but I'm still confused on your testimony. Are you saying that all of Garrett's needs together are medical, or parts of Garrett's needs are medical?
Cedar Rapids Community School District and I believe that all of Garrett's needs cumulatively become a medical service.
Ms. Seeds, it is of my understanding that these tasks that we need to be performed can be done by a school nurse, without the need of hiring outside help of any way.
Yes, Your Honor, but Cedar Rapids only has 6 nurses, and they cannot allow for one child's special needs to take away from the well-being of other students.
Well, if there are enough school nurses, then what is the issue?
Putting more nurses on staff burdens the school district's budget and can be avoided if these tasks were considered medical. The Iowa Board of Nursing did rule his care needed to be provided by a trained nurse. His constant need for care makes this a serious medical issue.
Each one of his services individually would without a doubt be considered related service. But what you're saying is that when you accumulate them all together all day continuously makes it a medical service? You're making this matter of numbers, not the natures of the service. I understand that Garrett has a one-on-one teaching assistant that helps him do the tasks such as raise his hand and move about the building. Can this individual be trained to perform these other tasks and ultimately release the burden placed upon the school nurses?
Yes, they could, but they would be trained to perform medical procedures, and that cost shouldn't be put on the school district. All I know is that the school district would love to give continuous one-on-one care to all of the students. Yet a nurse just for you? If that's not medical, I don't know what else is. If there's no further questions, I would like to reserve my time.
Very well, Ms. Seeds.
Thank you, Your Honor.
Argument of Douglas R. Oschlager. Mr. O.
Thank you. Chief Justice, and it may please the court, in Tatro, this court held that clean intermittent catheterization was a related service which the school district had to provide at its expense in order for Amber Tatro to remain in school and benefit from her education. In this case, the issue is whether additional services such as tracheotomy, suctioning, periodic positioning, and other services may not provide by a physician are also related services which the district must provide at its expense in order for Garrett Frey to remain in school and obtain the education.
But these services are acknowledged to be one of continuous nature, as the petitioner's lawyer described that a nurse would have to be there full time?
Yes, the petitioner categorized these services as continuous. However, we categorize them as intermittent. We believe the record in this case probably once or twice in the morning and once or twice in the afternoon, with the exception of the positioning service. Garrett would need suctioning once in the day, catheterization once a day, positioning for 5 minutes every hour. Other than that, all he needs is someone within earshot. And I would propose if you had a classroom teacher's aide or associate for some other child, you could basically train that aide to listen and intervene infrequently during the day, and the service could be provided in that way.
There is an educational aide with the child at all times, and can that person do any of the listening or positioning?
Garrett has an educational aide and is with him at all times. As for the role of the individual, they can certainly, with minimal training, can perform these tasks. For example, in kindergarten, in Garrett's kindergarten year, his 18-year-old aunt, Stephanie Madison, provided these services with no nursing training.
So you are saying that the record shows that such a person could do these and more continuous things, and the rest of it is intermittent need?
Yes, Your Honor.
Even if these were medical services, since you say most of the time they're not doing anything except listening to see whether he needs medical assistance now, I would take listening to see if he needs medical assistance to be diagnostic.
It is not diagnostic unless it's done by a physician.
Let me raise a question to you. If the facts were different than you say they are in this case, and if, in fact, continuous care by a registered nurse were necessary 24 hours a day, would your answer be any different? For instance, if a nurse had to be there full-time and the ambulance had to be outside the classroom at all times?
I think the question really gets to the heart of what is a related service and what limitations does the court adopt. The limitations in Tatro were expressed to be the child is handicapped so as to require special education. Only those services necessary to aid the handicapped child to benefit from special education must be provided. And the school nursing service must be provided only if they can be performed by a nurse or another qualified person. Not if they must be performed by a physician. We are only talking about services provided during the school day to get the child in the front door, to keep them there the whole school day, and to get them home.
Thank you, Mr. O.
Thank you, Your Honor.
The verdict of the case concluded that, in a 7-2 decision, the court held that if the services in question are related to keeping the disabled child in school and able to access educational opportunities available to others, IDEA-funded school districts must provide such services. The court added that although the nature and cost of providing certain IDEA-related services is not determinative of whether their financial burdens must be met, potential financial burdens shall inform any decision governing their provision. In the present case, the benefits of providing Garrett with his needed care outweighed the burdens.